Yeah, you mentioned earlier about the league's ability to control the team, and the league, in this case, as it was stated in some of the reports, was considered an insider and therefore had a fiduciary duty to maximize the creditor's interest throughout the process. How was that dealt with? We've read some things about the NHL stating its priority was to preserve the viability, goodwill, and success of the NHL as a major professional sports. Did that really take a back seat, or a front seat, sorry, to the creditor's rights in this case?
I don't think so, because I think ultimately they made the decision that they were going to make a bid that would pay the vast majority of the debt. And it was initially not approved. I won't get into the specific reasons why. But what ultimately happened... Sorry about that. What ultimately...
You were warned about getting too close to the mic. Yes. He wasn't kidding around.
Yeah. Within about, I'm going to say 30 to 45 days after the decision to reject the league's bid, in a hearing that wasn't scheduled to be a sale hearing, essentially everybody stepped up and said, let the league buy it. They'll refine their offer and delete the provisions that you said you wouldn't approve. And I don't remember the exact amount. I'm going to say they left about $15 to $20 million on the table that's still there and remaining creditors.
Not all the fees have been paid, but who cares? You get a good point.
But the insider issue comes into play in particular in the sale context, in the sense that, you know, normally someone who's an insider, someone who's an officer or a director of the owner can't screen out, if that person is going to bid for a team, he can't stop anybody else from bidding. Can't effectively act as a gatekeeper and say, you know, I kind of get an insider's advantage. I'm going to get to buy. I know all the details. I'm in a position to exercise a real advantage over anybody else. And so in a normal sale context, you have, as is happening now in the Dodgers, you have Blackstone come in. You have some other outside investment banker or somebody else who's taking charge of the sale process to make sure that it is fair, that everybody gets access to all the right materials, that nobody's getting an insider advantage. We certainly contended that by virtue of blocking Balsale's bid, by virtue of making the decision that he was not qualified to even bid on the Coyotes, at the very same meeting that they finalized their own bid for the Coyotes, that was really an exercise in illegal and improper gatekeeping, and so the vote, their bid should not be considered. With that one.
Susan raises it.
Well, actually, I mean, you argued, but since I didn't approve either bid, I didn't really have to decide whether the league was blocking Balsale. And then after what I call the second ruling in about October 1st, he basically said, I'm done. I'm not bidding anymore. I'm gone.
But it is as Susan Judge pointed out, it is kind of interesting, because if you look at the situation of both the Coyotes and the Dodgers, they're similar in this sense. The Coyotes, the league in the Coyotes case, acknowledged that they were essentially an insider. An insider is a bankruptcy term of art, which means you're making decisions for the debtor, you've got inside information. They acknowledged that. I mean, Gary Bettman just was very specific on cross-examination that yes, he believed he was an insider of the Coyotes. And if you look at the Dodgers case, you had Tom Schaefer, who was put in as the monitor, the trustee, whatever you want to call him, of the Dodgers prior to the bankruptcy filing. And so they're making, you know, this is an agent of Major League Baseball who's actually in active control of the operations. And the concept outside of a sports bankruptcy of an insider saying, I want to buy this team, and not only do I want to buy this team, but I'm going to use my approval process to keep others from buying the team. That's a no-brainer that's going to lose outside of the sports bankruptcy context. And it did become an interesting issue, but as Judge said, it became academic in that particular instance because the NHL bid was bounced on other grounds.
Mr. Salerno, we spoke before about this, about how a lot of people want to preserve the sanctity of sport and let them play, let them move, this and that. And you can't really force anybody to do anything in that realm. But what's the sense of NHL and the Coyotes as a business, which it is a business, and it's unique, especially in bankruptcy cases where they rely on other teams and they can't exist solely on their own. And can you speak a little bit to that about how this unique of a case is going to maybe set some precedent moving forward, and what can maybe the Dodgers learn from what we've learned?
I mean, look, when you're dealing with a sports bankruptcy, there is no doubt that it is not an ordinary business. It is in a highly regulated field. That there's this ultimate symbiotic relationship because, as the NHL pointed out, as the Major League Baseball pointed out, the Dodgers, if you have one team, you don't have a league, right? You need to have two teams, you need to have this whole organized thing. That's the only way it has any value. And so the sanctity of the sport is thrown out quite a bit. And look, I mean, there's something to that, you know. For God's sakes, baseball has a judicially created exemption for antitrust laws. I mean, the Supreme Court gives them a pass on antitrust laws. That's not your average business. I mean, that's pretty extraordinary, where the Supreme Court will say, you know what, you guys, we recognize you're probably involved in anti-competitive behavior, but we're going to give you a pass. And they did it in 1922, and that law is still valid law. I mean, it's still ongoing. And so this concept of, you know, the sanctity of the league, and that's going to give leagues more control over the process. That is a given. I mean, that is a given in a sports bankruptcy, unlike almost every other type of industry. There's other highly regulated industries, the gaming industry. You see casinos filed all the time, and there is a process. If someone's going to buy a casino out of a bankruptcy, they got to go get blessed by, you know, the gaming commissions. And so it's not like unheard of that happens. I would suspect, though, that in professional sports, because for so long, I mean, let's look at since the Bankruptcy Code was introduced in 1978, there have been 8 professional sports teams that filed, just 8. And 4 of those 8 have filed since 2009. The Coyotes was the 4th one to file. And since the Coyotes, you had the Cubs, you had the Rangers, you got the Dodgers and the Stars. No, Stars. So you had 4 filings since the Coyotes case in just a couple of years. So you could see that, and I suspect, frankly, there's going to be more. If this NBA lockout continues, I think you're going to see ripple effects. Ripple effects where these team owners don't have revenue coming in. But I guess my point is this: prior to shining the light of bankruptcy on a lot of these transactions, you can use things like, you know, for the good of the league, sanctity of the sport, etc. And that's just taken at face value because there's really no recourse, no real recourse, other than doing a midnight move. You know, you're trying to, let's test it. We're going to move first, and then we're going to test it. And you probably don't know this, Judge, but that was being considered. It was under consideration. We were told, why don't you just pack up the trucks? Because Swift Transportation does have plenty of trucks. Why don't you pack up the hockey team, take it to Ontario, so it's better to ask for forgiveness than permission. We said no. We think we're going to pass on that one, but it was thought. You know,
wouldn't you have had a little problem with your league covenant that your home games were vanilla?
Covenant schnuggling. Come on, you know. Let's not argue about niceties.
Let me say something about professional sports and antitrust, because it may be the only business where the participants are partners and competitors. And so, by their very nature, in the case of talk about this a lot, they have to engage in a lot of collective action to run their business and play their games. And you would never find all the major banks in the United States having meetings and talking about, well, collectively, let's run our business this way, and we'll all do this and we won't do that. I mean, clearly violation of the Sherman Act. But all professional sports, the cases have said, have this very unusual structure, and they have to have a fair amount of latitude to meet and work together to produce their product and generate the massive revenues that they do.
I guess my bottom line in terms of the future is that you do have to abide by a contract in a bankruptcy case. You can't just pick and choose, oh, I'm going to take these particular provisions and not those particular provisions. The only ones you can excise out are the ones that are really immaterial or the ones that are illegal. But you do have to comply with a contract, and you have to comply with a contract in good faith. And I think that more and more failing teams, of which there are several, or owners of teams that make a lot of money but who have amassed a large amount of debt, may well turn to the bankruptcy courts, because there you do have an arbiter who can say, you, Major League Baseball or National Hockey League or whatever league it is, are not exercising your rights to evaluate the criteria for choosing an owner or for moving a team in good faith. And good faith is a really important aspect of any business.
Right, yeah.
You know, the economics of professional sports are very interesting right now. The National Hockey League probably has economic issues with some of its owners. I was trying to find out the Dallas Stars are in bankruptcy. There's an auction, the deadline is passed. As far as I know, there's only one bidder, and that bidder isn't going to clear just the secured debt for the Stars. And if I remember correctly, the National Hockey League has loaned that franchise about $50 million. It has the first lien claim. Before the start of this season, the Atlanta hockey team was allowed to move to Winnipeg, which is where the Coyotes came from. And I don't know how long that had been in the wind, but my sense was that the league approved that move very quickly in comparison to what they will tell you the normal process is. And there are several other teams, and I'm not going to name them, that there's rumors about that they're somewhere on the cusp. I assume you all probably heard earlier today about collective bargaining in the National Basketball Association, but they've lost 1 month of their season, and that's going to cost the owners and the players probably in excess of $500 million. And let me just tell you, the debt structure in the National Football League, which is a tremendously economically successful engine. Now listen to these debt numbers. The league and the teams collectively have about $8.5 billion in debt today. And the individual teams collectively have about $2 billion in additional debt related to the stadium. So you are really talking about some unbelievably massive numbers that have to be serviced day in and day out. And at least according to a report that the league produced for the owners when they started the lockout in the National Football League in March, they were projecting that the lockout through July would cost them well in excess of $500 million. And if you notice, they kind of settled right on the edge of losing some of that season. I think it was the reality of, you know, if we don't cut a deal now, the losses for all of us are going to become astronomical. And you kind of compare that to the NBA, you know, they're supposedly meeting as we speak, and we don't know what's going on, but at least right now, nobody's playing games.
The thing I would add is this: when you look at the dynamics in these professional sports bankruptcy cases, every bankruptcy case other than professional sports bankruptcies, it's all about money, and I suppose it's all about money in these sports cases as well. But there's also this control element. But what happens is everyone gets together, they beat each other up, they punch each other in the nose, and then people say, okay, let's cut a deal. We just got to cut a deal. Let's get out of this mess. Because if we leave it to a bankruptcy judge to decide our future, while I'm perfectly content to do that in all times, but most people say, you know, let's be the masters of our own destiny, and you cut a deal. In these sports cases, it's really difficult to do that. Because Gary Bettman for the NHL and Bud Selig for Major League Baseball, they know that every financially distressed team in their league is watching really, really carefully what's going on. They watch what was going on in the Coyotes case. They're watching what's going on in the Dodgers case. Because if ultimately some judge says, that's right, I trump this power of the commissioner and blah, 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 you watch what's going to happen, and they know it. And so as a result of it, cutting a deal becomes so much more difficult because it's not really just about money. It's about maintaining this control element over the process that is hugely important. And they're unabashed about it. I mean, the leagues are unabashed about it. I give them credit. I mean, they're candid now. In the Coyotes hearing, the lawyer for the NHL, and this is in your materials, essentially said this, and it was a hearing on September 11th. He said, this is counsel talking to the judge. There are 3 things it takes to be an owner of an NHL franchise, Your Honor. Number 1, you've got to be wealthy. These teams aren't cheap to own and they aren't cheap to operate. Number 2, you've got to love hockey. Mr. Balsillie, he's got both of these in his favor in spades. Nobody denies that. But number 3, Your Honor, you also have to play by the rules that bind NHL owners. You know, there's an old rock and roll song by Meatloaf, the title of which was 2 out of 3 ain't bad. Well, that doesn't cut it if you want to get into the NHL. You've got to have 3 out of 3. Now, perhaps one day, Your Honor, Mr. Balsillie's passion for hockey and his resources to support a team and the league will meet with a recognition on his part, and he isn't above the rules that apply to all other NHL owners. And maybe he'll find a way, maybe, I don't know, to express an honest regret and a humility and acknowledge where he went wrong in his pursuit of an NHL team and apologize. Yeah, apologize for his miscues and sincerely ask for another chance to be considered. Maybe. This is statements in court. You know, if you kiss the ring and any other body part that we decide, maybe we'll let you in. It was good theater.